Welcome to Manifold. My guest today is Richard Sander, the Jesse Dukeminier Professor of Law at UCLA, an expert on the phenomenon of mismatch in higher education. And you may recall that I discussed mismatch with Richard some time ago in our first conversation on Manifold. In our second conversation, we discussed the oral arguments in the Students for Fair Admissions versus Harvard and UNC case that was before the Supreme Court. And yesterday, the Supreme Court issued a decision in those cases, which we are now going to discuss. So, Richard, thank you very much for joining me again.
Good to see you, Steve.
Before we get into the egghead stuff and the minutia of the law and the Constitution and how this will impact the future of American higher education and beyond, I just want to take a step back and ask about, as they say these days, the feels. So how do you feel about this decision, and how did you feel when you first heard about it?
Relief. I gave Edward Bloom a lot of advice when he was thinking about bringing additional lawsuits. So I have been aware that this was developing since 2013, 10 years ago. I helped prepare some of the materials used in the initial complaint in 2014. I was in the courtroom in 2018 during parts of the trial. So I've lived with this a long time, and it was great to see the Supreme Court nerve itself to do something that it hadn't quite been able to do in the Fisher decisions and the Gritter decision. So I was relieved that they bit the bullet and took the step.
And would you say how much of that is just the addition of the new, I guess Trump appointed 3 justices, is that right? Is the momentum shift here mainly just the flipping of previously more left of center justices to right of center justices?
Well, not entirely. So in both Fisher and Gritter, there was some expectation that racial preferences would be banned. But in both of those cases, Republican appointed judges sort of went through a conversion and ended up siding with the more liberal justices in both cases. In fact, that even happened with Bakke. Justice Powell was also a Republican appointee. So this has been an issue where moderate justices, I think, have really struggled. And one sign that was true even in this decision is that the Supreme Court did not actually overrule those earlier precedents. They simply distinguished them and sort of said, this has been a failed experiment. So to sort of answer the other part of your question, what is playing in here besides politics is that many of the hopes and expectations that moderate justices had for affirmative action have just been disappointed. There's just a much broader intellectual consensus now, I think, that affirmative action failed. Well, specifically that racial preferences failed.
So this case was filed, I believe, in 2014, and as part of it, obviously, through discovery, I guess the plaintiffs were granted access to a lot of data. And would you say it was that data that really convinced the court to update its priors on whether the experiment was a success?
Well, I think that helped. The court's decision was less data-driven than I had hoped, or that my friend Peter Arsidiakono, the plaintiff's expert, had hoped. There wasn't a lot of discussion about specific statistical finding. In fact, very little discussion of that in the case. So more important would be the fact that Harvard and UNC both sort of said, we need more time to make racial preferences work, but we can't give you an endpoint. The court really emphasized in its decision that in 2003, Justice O'Connor had predicted that preferences would no longer be necessary by 2028. And she also laid down various other restrictions and expressed concern about the possibility that preferences could turn into discrimination against other groups. And what we saw in these cases were all those concerns kind of coming to life. There was no sign in the arguments presented by either university that they even had a timetable for getting rid of preferences. And as you know, there was lots of evidence that Asian Americans were being disfavored by both Harvard and UNC, even more than whites. And there was very little effort by the universities to articulate specific goals that they thought were being achieved by preferences. It just came back to very kind of broad rhetoric about diversity. And, that I think made it easy for the court to say, this is just going nowhere. We've been doing this for 50 years and you're making the same arguments about, give us more time that you were making in the 1970s.
Right. So it was kind of a updating of priors over a long period of time and realizing that they were not close to solving the problem.
Right. So in 2003, Justice O'Connor was the swing vote for the liberal decision. And something that really influenced her, I think, was that the military filed a brief. And they said, we've been using affirmative action and we've made real progress. We've tangibly changed the shape of the officer corps in the U.S. military. So that's a real achievement and that's a reason to keep preferences. And my guess is that O'Connor thought, well, maybe the universities will get to that same place too. But the years since have just showed all sorts of reasons to think that racial preferences aren't working. Some of the ones that I've articulated, some of the ones that came out of the cases, anti-Asian American Convention was certainly very important. But a significant thing, Steve, is that the way this decision was written, by not overruling Grutter and Fisher, the court actually said that preferences by military academies could still be permissible. In fact, the decision, I think, can be read to say that any institution that can come up with a compelling argument for carve out could still use racial preferences. They just can't use the rationales that the universities are using for reasons.
Got it. So since you're starting to discuss the details of the ruling, would you mind just giving us a kind of overview of what the majority decision actually concluded?
Sure. The key point is that the court found racial preferences as practiced by Harvard and UNC to violate the 14th Amendment. They said that, in general, the 14th Amendment prohibits state actors or recipients of state assistance, like Harvard, from using racial classifications. They gave lots of examples of racial classifications that have been struck down. They said we've carved out in Bakke a narrow exception for universities to do this in particular ways, and we reaffirmed that in Grutter and Fisher. But there was a lot of evidence in this case, and a lot of evidence from broader practices of racial preferences in contemporary America, that those exceptions have proved unworkable. That you can't actually get universities to articulate compelling reasons to have more diverse classes that justify using race in a very ad hoc way. They found that Harvard and UNC were basically just using racial goals and saying, we want our classes to look like the same racial composition as our applicant pool. And we're going to use whatever size preferences we need to get to that. That's the sort of thing that the earlier justices in Fisher and Grutter, Bakke, and said you can't do. So essentially the court was saying racial preferences in American higher education no longer deserve a special carve out, and we're not going to permit it.
And would you say basing it in the 14th Amendment is a particularly powerful way to, in effect, eliminate affirmative action?
Yeah. I had argued, and I probably mentioned when we spoke in November, that a more modest way of reaching the same goal would be to find that racial preferences violate the Civil Rights Act of 1964. In other words, Congress in 1964 banned a variety of types of discrimination. And one part of the law they passed, called Title VI, applied to public education and private education to the extent that it was funded by the government. If the court had gone with that Title VI approach, that would have been more modest in the sense that it would have said, if Congress wants to change the law, they can change the law. It's just a piece of legislation, and Congress would pass a new piece of legislation. It would still be pretty dramatic because it's unlikely that a divided Congress is going to is going to pass a new law with affirmative action. But by basing the decision on the 14th Amendment, the court said Congress cannot change this. Even if Congress wanted to use racial preferences, they cannot pass that back into law. So that part of the decision is pretty dramatic.
So in the majority decision, I believe they specifically carved out, and I'll read the language to you. I'm sure you're familiar with it, but I'll just read it for the listeners. This was item F in the majority opinion. At the same time, nothing prohibits universities from considering an applicant's discussion of how race affected the applicant's life, so long as that discussion is concretely tied to a quality of character or unique ability that the particular applicant can contribute to the university. Many universities have for too long wrongly concluded that the touchstone of an individual's identity is not challenges bested, skills built, or lessons learned, but the color of their skin. This nation's constitutional history does not tolerate that choice. So my read of that is that one can no longer simply grant the preference based on ancestry or race, but one could still make room for a very specific part of the application, perhaps the personal essay, which shows that a particular individual overcame barriers to their earlier education or life success. You want to comment on that?
Yes, that's clearly the most important language in the opinion. And it's language that's certainly going to be litigated in future cases. It's important because if you didn't have some statement like that, then it could mean that universities could run into trouble with any sort of characteristic of an applicant they took into account that would have a disproportionate effect across racial lines. So even if they wanted to take into account, whether your parents went to college or whether your income was low or high, those factors could become constitutionally suspect if they had a close correlation with race. What the court is saying in this language, I think, is that as long as you can articulate a goal that's independent of racial diversity and show that you are applying this standard that helps you get to that goal in a way that is even-handed across racial lines, then you can use that characteristic, even if in the case of an essay, it involves a reference to race. So to be concrete, let's say that a university says, we want students who are going to have leadership potential. We want them to demonstrate leadership potential in their application. So if I write an essay and say, I became passionate about discrimination in my school. I'm Black, and I organized a civil rights group, and we had demonstrations, and we got the school to change policy acts. That's all fine, as long as it would be equally applied, equally acceptable for a white student or an Asian American student to say, I became passionate about homelessness, and so I organized my classmates to set up a soup kitchen, and so on and so forth. As long as you apply those criteria in a way that wasn't driven by race, reference to race is okay. Does that make sense?
Yes, absolutely. When I tweeted about this, it's funny that we reference Twitter now as, the place where intellectual conversations happen. But I tweeted about this yesterday, and one of the people who follows me immediately tweeted back saying, that clause that I just read is actually a loophole. And what is going to happen is that Harvard and UCLA are going to coach, say, Black applicants or guidance counselors writing for Black applicants to merely rehearse some standard trope about how because they're Black, they've overcome a lot, et cetera, and thereby through the back door smuggle in a boost in the admissions ratings that the Harvard admissions office or UCLA admissions office would give to that candidate. So that's probably the most cynical read of that clause that I've heard. I'm curious what you think about that.
Yeah, I don't think it's cynical. I think it's accurate. I mean, there's lots of that already happening in the UC system in California, which, as you know, has been under a racial preference ban for 25 years. UCLA even hired a huge cadre of African American applicant readers to sort of turn on their racial radar and try to find clues as to the racial identity of applicants in their essays. So it's definitely going to happen, and that's why I say it's certain to be litigated, because the next challenge, I think, will be a lawsuit against a university which is producing results that don't reflect sort of the academic composition of the applicant pool. And they'll put a university to the test and say, can you prove that you're not using this as a go-around, but you're actually applying this leadership standard or whatever to all races equally?
So I want to talk more about, what you think the litigation landscape will look like going forward. But before I do that, I just want to read a specific statement, which I believe was in Chief Justice Roberts' opinion regarding this point. And so let me just read that, and then we can discuss how we think the backdoor weaseling by the universities will work and the legal challenges to it. So this is Roberts. He writes, but despite the dissent's assertion to the contrary, universities may not simply establish through application essays or other means the regime we hold unlawful today. Parentheses, a dissenting opinion is generally not the best source of legal advice on how to comply with the majority opinion. End parentheses. Yeah. What cannot be done directly cannot be done indirectly. The Constitution deals with substance, not shadows. And the prohibition against racial discrimination is leveled at the thing, not the name. That strikes me as a very clear statement that he doesn't think that this sort of backdoor method should be allowed to happen. Maybe you can react to that.
Well, it's a clear statement and it's great language. And Roberts wrote a really well-crafted opinion. But it's very hard to implement that language. If a school is favoring students who bring up racial injustice in their essays, it's very challenging to show that that was done for invidious reasons. Some university presidents have given litigators a head start because they've issued statements like, irrespective of what the Supreme Court says, we're going to maintain our diversity levels. So that's kind of prima facie evidence that they're going to cheat. But in general, it's going to be very, very challenging to establish this. And, part of the challenge will be that when you file lawsuits, before you're even really allowed to discover, you've got to withstand a motion to dismiss. You've got to come up with some preliminary evidence that shows that the university is playing games. That's going to be very hard. Very hard to find a plaintiff, to find an 18-year-old who's willing to sort of go down in infamy as someone challenging a new generation of racial preferences. So I admire Robert's language, but it's going to be quite difficult to actually enforce that.
Right. I believe there was actually a message sent to members of the Harvard community and signed by the president, the current president, and the incoming president, which more or less said, we're going to use this. I mean, they literally cite that language in the decision saying we're going to use that to preserve, quote, diversity. And so,
Yeah.
go ahead.
Well, I've been thinking about this a lot, even before the decision, and uh, I'm working with some folks to try to develop model legislation. What I would really like to see happen is for some state legislators to enact rules that require universities to first be transparent about their admissions. In other words, provide data on their admissions process. Second, to clearly articulate what goals they're trying to foster. And third, do sufficient tracking to show that their admissions criteria actually help achieve those goals. If you can get even a few states to do that, um, that would give us sort of a gold-plated standard of here's what race neutrality looks like, and that would then make it easier to show and get through the courthouse door to say this other university clearly isn't doing something like that. They clearly could do something like that. So let us litigate this.
So I guess if we look at California as a specific case, there was many years ago, Prop 209 was passed, which prohibits, well, discrimination on the basis of race, but affirmative action, I think, in particular. And then that proposition was defended in 2020. Proposition 16, which was meant to repeal 209, was defeated at the ballot box. But my understanding of the history is that initially race blind admissions was implemented broadly through the UC system, but then gradually over time they've developed, quote, workarounds. And do you think something like that could happen nationally in response to this SCOTUS ruling?
Absolutely. The so there are two different things going on. One is that it was harder for UC to be race neutral than it would be for colleges nationally to do it now, because the elite UCs like UCLA and Berkeley and UC San Diego were and are competing against the whole national panoply of schools. So if UCLA went race blind and they made an offer to strong blacks in the applicant pool, those blacks would be getting more generous offers from other elite schools. They'd be getting offers from Harvard and Yale and Stanford that would probably include a lot of scholarship aid. So you'd have a race blind regime competing with a race conscious regime. So it'd be very, very hard for those schools to be competitive. It'd be very costly for them in terms of maintaining diversity, because the good students who academically qualify for those schools are getting lured away by more units. Does that make sense? You follow that?
Yeah, absolutely. I think that's what happened.
So yeah. So today, the potential is there for schools to have a much easier time of it. They can be race neutral, and if they expand their outreach mechanisms and they dig further into the pool of qualified applicants, they can probably still do a pretty good job. Black and Hispanic levels might fall some, but they wouldn't fall dramatically. So that's an argument for why there could be a good scenario where you had broad compliance and most schools made a reasonable good faith effort. But the bad story is that you now have this UC example that's occurred over the last 10 to 15 years at various campuses, where cheating has become rampant, and no one has brought a lawsuit against UC to take that down. So colleges across the country, I think, are more or less aware that UC has been doing this, and they're thinking, well, if UCLA and Berkeley got away with it, then why can't we? So you have both of those forces at work. There's the fact that the playing field has now been nationally leveled, but on the other hand, you have this successful example of cheating, not only by UC but also University of Michigan has flagrantly violated its state law against using racial profiles. So both dynamics are going to be at work.
Does the existence now of this SCOTUS ruling make it easier to bring an action against the UC system?
Yes, it does. One reason why no action was brought against UC is because by the early 2000s, the California Supreme Court had become very liberal. Uh, it was pretty politically balanced in the 1990s. You had generally a Democratic legislature and Republican governors. Um, but over the last 20 years, it's become one of the most liberal courts in the country. So um, lawyers who considered bringing suits against UC felt that even if they could prove their case in a lower court, the California Supreme Court would find some way to sort of reinterpret Prop 209. So the fact that you can now bring a federal action makes it a lot easier to bring an enforcement action.
Yes, that seems like an important change. Just to clarify the phenomenology, like what's actually happening, my understanding was that today at Berkeley, still the freshman class is only something like 3 or 4% Black. So they haven't fully worked around the law, have they? It's still a much smaller percentage than they would like. Is that correct?
Yes, that's true. But well, yeah, I'll say a couple of things. One is that um, Berkeley is cheating much less than UCLA is, and much less than many of the UC campuses are. So Berkeley has still maintained a significant degree of race neutrality. However, the 3.4% is a bigger number than you might think because the black population of California has been declining. Blacks only made up about 6.4% of all high school graduates in recent years, and 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 again, Berkeley is competing with schools that have been using strong racial preferences. So particularly Stanford is going to be a big competitor of Berkeley, and they've got it because they've been able to use racial preferences. So the 3.4% still reflects significant racial preferences. The other thing to keep in mind, though, that there have been many news articles sort of crying how tough race neutrality is going to be and how Berkeley and UCLA had these terrible declines in minority enrollment. Uh, that story is really exaggerated because it ignores the fact that both schools have expanded their transfer programs and both schools have dramatically improved their graduation rates. So Berkeley and UCLA, if you put them together, have many more Black and Hispanic graduates than they did before Prop 209.
That
So by
you know, I,
adding in the transfer factor, adding in the graduation factor, you get a radically different picture than if you just look at freshman enrollment.
I'm glad you clarified that because as somebody who actually follows this business, even at like a wonky statistical level, I was not actually aware of that fact.
Yeah, yeah. I spent a lot of time with actually three different New York Times reporters, and went through lots of statistical discussions with them, and they ended up reporting that quite well. But even the Wall Street Journal yesterday, well, I guess this morning, had an article that completely misrepresented what happened at UC after Prop 209. Very common, and it's a line that UC has pushed vigorously. They've throughout this Prop 209 era have been determined to present it as a catastrophe, even though it's abundantly clear in a dozen different ways that Blacks and Hispanics have done extremely well in the post 209 era.
I just focusing narrowly for a moment on your own work on mismatch theory, it would seem to me that if you had full access to all the post Prop 209 data, I guess before and after, you could really demonstrate very solidly that your theory is correct, right? Because you have scenarios where lots of academically underqualified kids were admitted and didn't do well in the actual undergraduate program or had to switch to easier majors. And then in the post 209 era, when compliance was good with the law, then you had well matched kids who did, as well as the white or Asian kids on their campuses. I mean, it just seems like if you had full access to the data, your theory about what is actually happening would be vindicated very strongly.
Yeah, and we probably talked about some of this story in one of your earlier podcasts, but rough, quickly, I did get decent data in 2008 from the UC Office of the President, and I shared that widely with academics. And several articles appeared in the 2010s demonstrating this. The American Economic Review had a flagship article showing how science mismatch had dropped significantly at UC after Prop 209, and the number of Black and Hispanic science graduates went up dramatically. So yes, we were able to demonstrate the mismatch effect strongly. But then UC completely clamped down on data access. They refused to let us do further updates. And the data that they gave us understated the mismatch effect because it was not as granular as one would really like. And as you know, the less granular data is, the harder it is to show effects that actually exist. Then UC went even further, and they gave they gave the dream data, the really good data, to a young graduate student economist named Zachary Bleemer, who's now an assistant professor at Harvard. And Bleemer then came out with a couple of very misleading articles that seemed to show mismatch was not as significant as we had argued. But he wouldn't release the data. He said he was bound by contract not to share his data with anyone. So you've got this very aggressive propaganda effort by UC to try to kill the real story.
Yeah, thanks for reminding me of that. I remember you went through this with me before. I had forgotten about Bleemer. It makes me want to cry. Uh, but okay, so let me turn to something else. So the actual defendants in these two cases, Harvard and UNC, what will now happen? Will the federal judges that were involved at an earlier stage oversee the remedy? How will what next will happen at those two institutions?
Yes, both cases will go into a remedy phase, and SFFA's legal team has been working on what their strategy should be. I'm pretty sure that they will be stuck with the two judges they had before, which is unfortunate because both of those judges were, I think, strongly biased in favor of the universities. So they'll try to, make their best out of that. What's pretty clear, though, I think, and will be hard for the judges to resist, is at least having a significant level of transparency, so that SFFA will be able to have the kind of data access that they had during the litigation to see what happens um, in the initial years afterwards. And there will probably be some sort of discussion about exactly how these essays can be used.
How this is kind of a in the weeds question, but I just personally curious. When the Supreme Court, comes back with a very strong decision like this, do those justices ever kind of look in and see what the appellate judge is actually doing? The one that lost, the one that's overseeing the case. I mean, could that person be slapped down if in some way if she is not actually enforcing the ruling properly?
Well, the lower courts have effectively been chastised by this decision, and they know that if they don't try to implement it in good faith, SFFA will be able to go back to the Supreme Court.
I see. So they have a sort of quick path to go back to the Supreme Court, or would it take another 9 years?
Well, it'll take long enough, but not 9 years, and there'll be a fair amount of confidence with the 6-3 decision that the Supreme Court would stick to its guns.
Got it.
In Fisher, you had a somewhat similar situation. Fisher one remanded the case back to the lower courts to look into whether they had actually shown benefits from diversity that could be tied to particular admissions practices and so on. And the Fifth Circuit sort of, did a very shallow job. It was taken back up by the Supreme Court. They granted cert, but then Kennedy kind of backed off from its earlier decision in Fisher 2 and gave the university a pass. So in that case, you had essentially a defiant lower court that took a gamble the Supreme Court would change its mind, and it did.
So in this case, I mean, I think the judge in Boston was named Burroughs. If I had to guess and model her psychology from afar, I would guess that she, just like the Harvard administrators, thinks this is some terrible perversion of American jurisprudence by a conservative, terrible Supreme Court. And therefore, she probably has no moral compunction against doing everything she can to aid Harvard in the aftermath of this ruling. Am I too cynical?
I don't know. I thought Judge Burroughs' opinion was pretty awful and ignored mountains of empirical evidence that SFA experts very professionally put together. But you know, she did make decisions during the discovery process that were very reasonable decisions. She gave the plaintiffs a lot of access. You know, when you go through a trial like that, there are many, many decision points for the judge, and Burroughs did not try to shut the discovery process down. I think she was fair during that process. So, there are ideologies and there are also traditional norms, and you can't really predict how that's going to play out in an individual judge's mind. In other words, I wouldn't say that Burroughs is going to be determined to undermine the decision. Uh, she may have felt, I believe in preferences, and I'm going to write a decision that eloquently justifies them, but if the court overrules me, I'll try to implement that in good faith. We'll have to see.
Yeah, that's reassuring. Emphasis here being on judicial norms holding sway over personal ideologies.
Oh. Yeah, and they're real. I mean, judges have difficult jobs, and I know a lot of judges, and I know some judges who have made outrageous decisions, but most of them really do try to be very professional, and they try to be fair.
So let me describe what I see looking closely at the current situation for college admissions. Literally every school now, every elite private school except MIT that I know of, has now made the SATs optional. And even Caltech, my alma mater, which used to be very meritocratic, has actually gone to the opposite limit. So they are telling applicants to not report or try to report anything about their scores in their application. They're very strongly warning students not even to smuggle them in. Like in your essay, you could say oh, I was very happy that I got 1,600. You could say that and smuggle it in, but they even tell you not to do things like that. So possibly because traditionally the faculty at Caltech really do want students with top scores. And so maybe the administration is trying to keep that information out of the process. But be that as it may, only MIT, which went through a internal study, they had dropped the requirement for the scores during COVID and then realized they had consequently admitted a lot of students that were struggling at MIT. And so they concluded after active study, they definitely needed the scores. Sadly, Caltech is at the opposite limit, but basically so are all the other elite schools. And so it seems like if I wanted to continue a de facto affirmative action policy, I would encourage all the white and Asian students, the gunners, to submit their scores so I can continue admitting. I don't require it, but I sort of, I sort of spread the word that, hey, if you're white and Asian, you better have top scores or you're still not getting into Harvard. But I don't collect scores on the people that I want to be the beneficiaries of preference. And then it just becomes much, much harder for SFFA, to sort of demonstrate that effectively a system of preferences is still going on, but they now lack the data. The school deliberately fails to collect the data that one would use to demonstrate that's going on. Maybe you could react to that.
Well, I think that the next pieces that develop in this area are going to be driven to look at outcomes rather than just the admissions process. Because you're right, universities will make their admission processes more opaque, but they'll still assign grades. There's been a lot of grade inflation, but I don't think universities are quite prepared to get rid of grades yet. So if you could show that, regardless of the qualifications, you're having a huge performance gap along racial lines in your student body, then that's going to create a presumption that you're discriminating. That'll then be an effective way of shifting the burden of proof onto the university. Say, okay, so tell us how you are arriving at this class that has these wildly uh, different academic outcomes.
I think that I agree with your point there, but let me just mention a couple of aspects related issues. Already in the Ivies, as you know, the average grade is close to an A. So, so discrepancies in performance among groups might be very difficult to tease out. And also, if the gunners are the ones taking the hard classes and the preference admits are taking very easy classes, that effect would have to be accounted for. So you might end up back with this sort of dueling statisticians situation where the school's doing everything it can to make it hard for the plaintiff's statistician. So I'm still worried. It seems like the policies that these schools are implementing are almost deliberately in advance of this decision, trying to pave the way for their response.
Yeah, and I don't want to imply that I'm not worried. Uh, there's a real possibility, maybe even a probability that things would get worse under this new regime. That schools will just move away from performance measures, move away from qualifications if they find they're losing too many strong students to competing schools. There's still, there's still strong incentives to preserve the eliteness of their student bodies, and they can't have different race-based rules for who submits scores and who doesn't. So that's all to say it's going to be a complex game of chess.
Yeah, I agree. I think the most interesting thing will be whether all the elite universities, maybe with the exception of schools like MIT, sadly not Caltech, act as a block and basically adopt all the same kinds of strategies, or whether somebody, maybe Chicago would be like this, will break out and, comply in spirit with this decision, not just with the letter of the law.
Yep. Yep. Well, so let me go back to my earlier point: is that if you get some state legislatures to pass laws that really mandated transparency and then mandated that the universities articulate their goals and show quantitatively how their admissions criteria fulfill those goals better than other alternatives, you would really have a model. You'd have, some good state universities modeling. Here's how to do this fairly, um, and that would create a very helpful competitive pressure on the schools. Be a helpful political pressure and a helpful litigation pressure. So some kind of path like that, I think, is maybe the most hopeful one for getting real reform in higher education.
Yeah, I definitely feel that working on model legislation uh, for states that want to implement this, I think it's very valuable. Let me ask you just one more question, and I'll let you go. I appreciate your time. Can you just talk a little bit about effects of this ruling beyond higher education? So on or beyond admissions. So maybe faculty hiring, or maybe even hiring at private companies, things like that. Do you see any downstream consequences?
Absolutely. I spoke to a reporter a few hours ago about the report of California's reparation committee. You may have heard that yesterday was not just the Supreme Court opinion, but it was also the delivery of the final report of California Reparations Group, appointed by Governor Newsom, that is recommending something like $880 billion in reparations for blacks in California. And the chair of that commission gave a press conference and said, I'm disappointed in the Supreme Court's decision, but fortunately nothing that they said is going to apply to us because we're basing our reparations on life experiences.
Good.
So I think that's not going to quite work. Any sort of reparations effort is going to be challenged based on this court decision. And from what I've read of the Reparations Commission, they did not do a good job of showing that individual life experiences in the 21st century were directly and immutably shaped by the experience of their 19th century ancestors. So I think it's going to have a chilling effect upon all sorts of race-based equity efforts that have proliferated in the last several years.
Great. Well, again, I appreciate your time. I know it's late in France, and I hope that you can enjoy the rest of your vacation, although I'm sure there are plenty of other reporters that would like to talk to you. So, thanks.
Well, talking to you is uniquely valuable, Steve. I always learn a lot from our conversations.
Wow, likewise. I appreciate that. That's very kind of you. My guest today has been Rick Sander. Perhaps we'll take this topic up again in the future. Thanks again, Rick.
Take care.
Yep. Cheers.
Cheers.